because we should not have our elders and our people with disabilities just barely existing, particularly if they have no other support systems like families and such to provide them with additional support.
We are here with Caren Cafferata-Jenkins on the issue of estate planning for Nevada families. Why don't you start off with a little introduction about yourself, what you do, and your law firm and the areas of practice.
Great, thanks, Alex. I'm Caren Cafferata-Jenkins, and I have been a Nevada attorney since 1996. A little over what, 25 years. That's just, I don't know how that happened. I've been practicing, I had been practicing both in California and Nevada for that time. I did a clerkship at the Nevada Supreme Court, which was quite an honor way back when, and have been practicing since then in litigation. I started out as a commercial litigator in Las Vegas, and then went to San Francisco and did international commercial litigation. And when I came back to Carson City in just after 2002, I continued that litigation practice for some time, and then eventually realized that I have a passion for people with disabilities, families planning, both my own and those around me. And I liked creating, solving problems before they occurred, rather than creating problems and fighting about them. So my practice at this point is with my own firm called Nevada Legacy Law. And we do estate planning and probate. We do trusts, and we help people figure out how they want to be remembered, how they have accumulated their wealth, whether small or large, and how to assure them that after they're gone, it does what they intended for it to do, without any ambiguities. So my years of writing for the court now are paying off for my clients and for my family, to make sure that plans are in place so that after we're gone, our intentions are honored.
So I like that you mentioned avoiding conflicts, or I guess litigation before it occurs. And we are going to talk a little bit about probate, but we're going to work backwards in this video and talk about how your work specifically will affect probate before we actually get into those questions. So I guess we should start with the more basic of all questions, which is, what are some of the basics involved in estate planning for Nevada families?
Sure. Once upon a time, way back in British common law, the king would own everything. And families were reliant upon the king to tell them what would happen when the patriarch of a family would die. And nowadays, instead of a king, we in the US have courts. So in estate planning, now that we have our own possessions and the king doesn't tell us what we own and don't own for the most part, I'd at least say, we can create those decisions for ourselves. And what we typically do is that if we are informed individuals, and I hope that we all are, or we're not watching this show, if we're informed individuals, we can identify those trusted insiders, the people we believe will honor our wishes after we're gone. I often say, well, even the most honorable person needs to ask themselves, do I behave the same way when no one is looking? And if the answer is yes, hopefully you've got a couple of those in your life. And you can say, I want you to make sure that all the work that I've done in my lifetime is passed along to those whom I wish for it to receive it, whether it be my family or not. So those of us who are informed can create estate plans that do not rely upon the king, or in our case, the courts, not only to tell us where our stuff should go, but also to tell us who should collect it, evaluate what's there, liquidate it, and distribute it according to our wishes. So those of us who are informed can create trusts, whether we have a lot of wealth or a little wealth, doesn't matter. And we can create those to designate our trustee and avoid the courts altogether after our deaths by placing all of our valuables, all of our personal items, all of our sentimental items into a trust. And by doing so, the court and the government doesn't need to provide a safety net for us. We're setting that up ourselves. It used to be that only very wealthy people would have trusts. Well, only very wealthy people would have access to lawyers too. That's no longer the case. So now, if a person creates a trust as part of their estate plan, there is no probate process, there is no court involvement, and the individual is in charge of their own life and their own assets after their death. The second thing is, if you don't have a trust, you can have a will. We've all heard of our last will and testament, happens in the Westerns all the time, right? But if we just create a will, the government still steps in and says, we're here to ensure that the individual, the decedent, the dead person has identified as trustworthy. We're here to ensure that the guardian of their children that they've identified is appropriate. And we're here to ensure that the beneficiaries they've identified are the ones that are before the court today with their hands out. So when there's a will, your wishes are communicated, but the court oversees the process. And then, of course, those of us who die without any planning, the distribution of our assets falls to statute. Legislators have said there are these degrees of consanguinity is what it's called. Consanguinity refers to blood. So your spouse, your children, your parents, your aunts and uncles, your cousins, etc. And those outward trending circles are the individuals to whom your assets should go. And that's what our Nevada statute says. And again, the court finds those people, names an administrator, and distributes according to the law rather than your wishes. Those are really the three categories of estate planning that there is.
Okay, so we have the trust process, the will and testament, and how it impacts probate, and then the statutes, which are just kind of there for people who haven't planned at all, is what it sounds like.
That's right.
Excellent. So you covered some of the follow-ups that I had. I do have one follow-up. I am curious whether or not, because I know people do fight in probate, I'm curious whether or not it is something that can occur for family members to target and sue a trust.
Well, certainly anybody in America can sue anybody else. The question is, do you have standing to bring the dispute before the court? And if you are not a designated beneficiary of a trust, you have no standing. You can't make a claim against a trust. I mean, you can bring a lawsuit, but it'll be thrown out in most cases. If you're not a designated beneficiary, you have no business in a trust. And certainly, because an individual went to the trouble to create a trust, it's presumed that they knew what they were doing and they intentionally omitted someone who might think they're entitled. Now, rarely are intentionally omitted heirs given standing. And whoever's writing that trust for you can certainly say, I know I have a son named Alexander Falcone, and I do not want him to receive any part of my estate. And I'm sorry, Alex, but you're going to have a really hard time showing the judge that the person who wrote it didn't mean it. So if you were to sue that trust, you're probably going to have the matter dismissed. Now, of course, creative individuals who want to challenge a trust might say, well, my parent, my friend, my whomever wasn't in their right mind when they wrote it, or was being influenced by an outside source, another beneficiary perhaps, or, they'll come up with something. And in those instances, if there's even a modicum of evidence, the court will probably hear it. And then, of course, the evidence rules, and the judge will determine whether the challenge is has basis or not.
Okay. That does make sense to me. Thank you for taking that. The next question, let's go into family members with disabilities and how that would impact estate planning.
Well, and you know, this issue is near and dear to my heart, and it's become an area where I've developed some expertise out of necessity. I have a son with special needs. Actually, I have two, and I jumped into special needs or laws as a result of that. I've become very familiar with, you know, rights to education and rights to public benefits and rights to various things, and also the right to, if a person with a disability is a recipient of public benefits, rights to have gifts directed in a manner so that those public benefits are no longer being challenged. Often people with disabilities are reliant upon Medicaid, for example, state provided health insurance, or they are able to earn a living to some degree, but require some assistance, supplemental security income, for example, or Social Security disability income. Now, if an individual earns or receives too much money, those public benefits disappear. And if that money comes in one chunk, maybe it's a big chunk, but one time, those benefits disappear. And when that gift is utilized properly and is gone, the individual has to reapply for those public benefits that they would otherwise be entitled to. And let me tell you, those public benefits are not generous. They're very basic. As a matter of fact, I think the Social Security disability income level right now is about $770 a month. And that's to pay for housing and healthcare and transportation and all of the basic costs of life. Think about living on $770 a month. I couldn't come close. Of course, food stamps would be available to some, and other public benefits like housing assistance, but it's still a meager amount. But if a person with a disability receives a inheritance that is properly directed, that inheritance can be made available without any jeopardy to the public benefits. And that's a wonderful gift. And it can be made available to supplement, not to take the place of, not to supplant those public benefits, but to supplement their quality of life. For example, an individual with a disability who's receiving a disability, Social Security disability income, probably can't afford cable TV, because right now that's like $200 a month for basic services. But a special needs trust that receives a distribution from an inheritance can be made available to pay for extras, whether that be education, it could be transportation, it can be entertainment, it can be personal care, a personal care attendant. It can be a lot of things. And the IRS has exempted assets in a special needs trust from those countable assets that the Social Security Administration looks at. Now, who knows about these things? Only people who do a lot of digging. And so I've started digging because I hope to leave some money to my children upon my passing, but I sure don't want to have it put them in peril if they're unable to earn a living. So I've become very familiar with special needs trusts and the various iterations of those. Third-party special needs trusts come from a third party. First-party special needs trusts come from an individual. So if I were to have a traumatic brain injury today, because I do ride a motorcycle, if I were to suffer a traumatic brain injury today, I have assets. Those could be put into a special needs trust by me for my benefit and be exempted from my eligibility for those public benefits. So it's a balance. It's a balance. The other thing that I've become aware of for special needs or people with disabilities is the ABLE Act. Now, that's a pretty new animal. It was created in 2013, signed into law in 2014 by Barack Obama. And ABLE stands for Achieving a Better Life Experience. And it was intended to enhance a person with a disability's ability to live, not just survive, but live. So those of us who might have a child who is identified with a disability prior to age 26, random number, age 26. As a matter of fact, there's currently a bill before Congress to raise that to 46, that the disability has to have been identified and have been onset by age 46, but currently it's 26. If the disability is identified as existing before age 26, I now can start saving for my child or my friend or my acquaintance who's been identified with a disability, because I know that this individual should have better than a bare basic life. And I want them to have a better life experience. And so I can contribute to an ABLE account set up on their behalf. And believe it or not, it's a 529 plan, very much like college savings plans we're all aware of. But this is a 529 different lowercase letter than the 529 plans. But I can put in up to $100,000. And the ABLE account can hold up to $100,000 for that person's benefit to supplement their public benefits. And what a wonderful gift that would be if we become aware of a person whose disability was identified before age 26. I have a friend with a child with a disability. He was diagnosed with adolescent onset schizophrenia at age 16. Often these things aren't diagnosed until well into the 20s, especially for men. And this young man has the opportunity to set up an ABLE account and have his grandparents and his parents and his friends contribute to it all the way up to $100,000. And it will not have any impact on his ability to be eligible for public benefits. And that's a blessing, because this young man is unlikely to be able to support himself. So, you know, these tools I've become aware of because of my own personal need. And I want to shout them from the mountaintops, because this is a very much a needed exemption, because we should not have our elders and our people with disabilities just barely existing, particularly if they have no other support systems like families and such to provide them with additional support. We can put these things into estate plans so we don't inadvertently put into jeopardy those public benefits by leaving money to someone we know could use it.
So it sounds to me like a trust is a business entity separate from, you know, an individual, but it does make me curious. Now, you've mentioned that it follows instructions, that it has beneficiaries, and I assume that's where somebody where you're with your expertise is involved steps in and kind of helps put that together. But I'm also curious as to who it is that runs or controls the trust and how that works.
Great question. First of all, one of the most important decisions one might make in a lifetime is selecting a successor to one's own judgment to manage our affairs if we become incapacitated, like that brain injury I was talking about, or become deceased. In a trust, our success, we might be the trustee of our own trust while we're alive. But if I were to have that brain injury, I will have identified an individual I trust. That's why it's called a trust, by the way, to manage my assets for my benefit. Not to take those assets for his or her own benefit, but to be a fiduciary. And a fiduciary is held to a way higher level than just a friend or somebody doing you a favor. A fiduciary must put their own interests aside in favor of the beneficiary for whom they're a fiduciary. So I've named somebody to take my place, to stand in my shoes, manage my assets on my behalf, and spend those assets for my benefit for as long as I'm alive. And thereafter, to distribute those assets to my named beneficiaries, whoever they may be, in my place. That fiduciary is a tough person to pick. And often it used to be in wills that, the eldest child would always take over, actually the eldest male child. That no longer is tradition, that tradition is gone. You pick the person who's got the financial savvy, the understanding of you, your ideas, your intention, your facts, your circumstances, your family, and who knows what, and pledge to do what you've directed them to do. And that person does exactly that and no more, no less. Now we've all heard about, the Trump family. They're a bunch of trust babies, right? Well, trust me, no beneficiary of a trust has ever been happy with their fiduciary, the trustee, because the fiduciary's job is to say no, unless it's specifically designated and directed by the trust. And fiduciaries have a great deal of discretion, but they still have to work within the parameters of that document, that written trust. And if the written trust didn't contemplate the possibility of something happening in the future, the trustee has the discretion to say, well, I know Caren didn't like this, and I know that she really wanted her children to do that. So what would Caren have done? We're not making, banners WWCD. What would Caren do? But at the same time, that's the fiduciary's job if the fiduciary is given that discretion. So within the context of the trust, the fiduciary has great discretion. And I typically require my grantors, the people creating the trust, to name 2 or 3 levels of trustees. If not me, then whom? If not her, then whom? If not him, then whom? Before I let them sign the document, because stuff happens. And when I'm talking about an estate planning trust, I am talking about a family revocable trust. Now that word means it can be revoked, it can be amended, it can be thrown out altogether, so long as the person who created it has the ability, the capacity to understand what they're doing and be able to sign their name before a notary and say, I want to make this change. It can be changed again and again and again, just like a will. Now, you might have heard of irrevocable trusts. You might have heard of all kinds of trusts, life insurance trusts, and intentionally defective grantor trusts, and all kinds of things. We're not talking about those. Those things are put into place for tax purposes, not for inheritance purposes. So when I'm talking about estate planning, although we always try to minimize taxes if at all possible, we're not talking about asset protection. So just want to clear that up. So your fiduciary, who deals with this when you're gone? Your designated successor trustee in the order that they appear in the trust. Same thing with your will. You select an executor. You've heard that word before. An executor is the same thing as a personal representative, which is the same thing as an administrator. I mean, all these words are interchangeable in various contexts. That's the person who's going to manage it after you're gone. So in a will, we also name our executor. And if not them, then whom? And if not that person, then whom? And I like 3 levels of coverage there, because often somebody would say, I want my eldest child. And if not the eldest, then the next. And if not that middle one, then the next one. Well, what happens when they're all on a family vacation and the Titanic goes down? Or they're all in the same car accident, or God forbid, plane crashes or whatever. So I always have at the very, very last in a trust, somebody called a trust protector who has the ability to name someone if the list is extinguished. And in the case of a will, if you name everybody that you know and none of them are available, a court will assign somebody. Sound good,
Okay.
Alex?
It does. So I guess one of the things that jumped out to me was that it looks like the trust itself is designed and the court isn't involved unless someone sues it. Whereas with probate, inevitably the court has to be involved. Is that something that I am assuming correctly?
A trust never has to go to court.
Never has to, but it could potentially if it was
That's
sued.
right. And certainly a wise fiduciary, if there's an ambiguity in the trust and he or she doesn't quite know what to do, might go to the court for guidance rather than put their decision on the line and wait for it to be challenged. So there's no reason for a trust to go to court if it's drafted properly and everybody plays nice, which sometimes actually happens. But indeed, a will, by design, goes through that process that everybody hates the words probate. Probate is simply the act of our government being the safety net to make sure everything goes according to the dead person's wishes. And if there's a little money at stake, $20,000, there's something called a set aside. You just kind of drive slowly past the courthouse and they say, oh, not enough money to worry about. Actually, you actually file documents. And if it's not very much money, there need not be even a full hearing. If there's $20,000 to $200,000, there's a summary proceeding if the value of the estate is that much. And that means, you know, you have to go through the process of having an executor named and tell the court how much is in the estate and to whom you propose to distribute it according to the will. And the court generally approves summary proceedings so long as all of the lines match up. Now, anything over $200,000 in the state of Nevada goes through a full-scale probate. They're time-consuming, they're public, they are expensive because one needs to have appraisals and inventories of assets and open public hearings and invite everybody and their brother who might have a claim, including creditors. And the court oversees the expenditure of every dime. And nothing's done without court approval because the legislature has determined that if your estate is over $200,000, it's at risk of being stolen from. And so the court, again, plays that safety net job. And it's a rather patriarchal concept, but it's important that the court approves before any action is done and confirms after it's done that it was done according to the will. And when I say it's expensive, attorney's fees in a probate are provided for in statute. It's 4% of the first $80,000 of assets, 3% of the next $20,000 of assets, and 2% of the remainder. That can be substantial, especially with the value of housing right now being up in the several hundreds of thousands of dollars range. The assets in an estate can be, you know, close to $1 million rather quickly. So it's expensive because it's a percent of the estate. The time typically is 6 months to a year or more. There are timelines that need to be followed about publication. We've seen the notice of trustees sale or the notice of notice to creditors published in the back of the newspaper. All of that's related to probate. So the court assures that everybody who's entitled to a dime has notice, the ability to come forward and say why they think they're entitled before a distribution is made. So I advise my clients to avoid that process because of its expense because of the complexity of it. And if at all possible, plan for it. Because if we know somebody we trust, and we know what we want to have happen with our assets, we can accomplish that for pennies now rather than pounds of money later.
All right. I really don't have any more questions. I guess if you have anything else you'd like to mention, feel free to go ahead and add that in there. But otherwise, I will just thank you for your time and appreciate you coming on.
Thank you, Alex. I would like to just close with saying anybody who's 18 years old or older, whether you have children, whether you even have a savings account, put together a will at the very least. If you have children, that will must include a nomination of a guardian for your minor children. If your children are under age 18 at the time of your accidental death, you want to have a say in who's going to have guardianship over them. You only get to propose somebody. The court is going to appoint the guardian. So nominate one in your estate plan. And if you have a home or assets valued over $200,000, which is a number set in statute long ago, so it's a much lower burden now. I mean, again, if you're a property owner and you've held that house for more than 2 years, you have more than $200,000 in assets. Boom, automatically. Your estate will go through probate and your intended heirs will not receive the full extent of their benefit because some of those funds are going to have to go to lawyers. Why not spend a little bit now? Put together a trust. My trust packages go for under $3,000 for a couple at this point in time. Whereas an awful lot of the probates are going for over 10,000 for attorney's fees in probate. Makes sense to me to spend a little now and save a lot later.
Makes me really want to provide electronic coverage of a trust proceeding, maybe a probate proceeding one of these days, and we can come back and try something more technical. But really appreciate your time. I think it's an issue that's important that people just really don't think about. And hopefully after watching this video, it's something that's on more people's radar. Thank you so much.
My pleasure.